In July of this year, information came to us of a very serious allegation with respect to the conduct of a particular public official, namely matters relating to the Attorney General and his ownership, importation, licensing or otherwise of a motor vehicle, a Range Rover. When we looked at the information, it appeared to us that there were issues surrounding the licensing of this motor vehicle. And I'm making this very clear because this matter has been in the press for the last few days. And there's a certain amount of confusion with respect to two motor vehicles. And in that confusion, while our complaint has been sent to the Integrity Commission, the Attorney General, with all these questions to answer, has made a statement that he sees a conspiracy between the opposition and the Integrity Commission and others against him. I want to make it abundantly clear that there is no conspiracy between this office and any office holder, and the complaint that we have sent to the Integrity Commission is simply that, a complaint requesting an investigation, because the Integrity Commission is the investigating body under the Constitution to treat with matters of this nature. And for the benefit of the public, let me clarify what we have done and what is the substance of the matter which we have put before the Integrity Commission. We received documentation which showed that attempts were made to license a Range Rover in 2012. I think it's PCX2. And when we looked at the documentation indicated that attempts were made to license this vehicle as a duty-free item. Now, we all know that office holders, like the Attorney General and other public officers, as part of their terms of engagement, are entitled, if they so choose, to access the purchase of motor vehicles with all taxes foregone. That is not an issue. The Attorney General is entitled to that. That is not an issue. But this particular vehicle, the attempt to license it, resulted in two customs forms being signed. One where a significant sum is alleged to have been paid, and that payment was supposed to have facilitated the licensing of the vehicle. That was not done. Another similar form signed by customs showed that the vehicle was not subject to duty. And also there was a document from the VAT office which indicated that the vehicle was VAT free. When we examined the documents, the reason why we sent it to the Integrity Commission is because we wanted an investigation as to why these confusing attempts were being made to license a vehicle in a pretty straightforward way, where if the authority for licensing it was granted, there should have been no problem. We are now seeing in the newspapers that another vehicle owned by the Attorney General comes into view, having accessed the provision of duty-free conditions, but that was not discharged at the time when this PCX2 vehicle was attempted to be licensed. Let me tell you the significance of that, which the current conversation has completely missed. If a public officer is entitled to a duty-free vehicle, after 2 years, once you can confirm to the authorities that the vehicle has been disposed of, you then can make an application for another concession on another vehicle. However, in making that application for the duty-free on the second vehicle, you have to satisfy the Ministry of Finance that you have in fact disposed of the first one, or settle the loan. If you have settled the loan, then you are entitled to another duty-free item. If you have not, then the period of 2 years will expire, you're entitled to. If, on the other hand, you still retain the vehicle, the first one, and there is a loan condition on it, and there are duty-free conditions on it, then you are not entitled to another one at that time. So the issue now arises as to, in the case where the first vehicle remains with the Attorney General, what attempts were being made to license the second one duty-free? And we sent this to the Integrity Commission to determine by investigation whether the documents which attempted to license the second vehicle duty-free were in fact fraudulent actions within the public service. Because these customs documents are not signed lightly. And there were 2 of these documents saying 2 different things. And there's a VAT document which is not kosher. And that is the one in that arrangement where the 2 vehicles carry the same number, the same engine number, is it? So all of these confusions came to us here in this office. And we sent it to the place where investigations are required to be done. That is the Integrity Commission. And we kept our peace then. Subsequent to that, we saw the Attorney General, whose vehicles are the ones of discussion as I've just described them. We saw him on a political platform with documents from the police which had been investigated or were being investigated with respect to a citizen's purchase of a vehicle that might have been stolen, and the Attorney General was then making a big issue, quite improperly, with documents which ought to have remained within his department and handled in a particular way. He was out there leading the charge against Ms. Dionarine, and one of the questions he was raising with her is, why didn't she buy her vehicle from the local agent? Well, you're free to buy from who you want to buy from. But here is the Attorney General on a political platform with the file of a citizen where the matter is being dealt with by the state. And he was on a political platform prosecuting a case and accusing a citizen of criminal conduct. But that's a separate matter. The matter which is before the Integrity Commission is whether there were attempts to improperly license a vehicle, and whether the confused documents, including the customs documents, the VAT documents, and the licensing documents, whether those inexplicable contents were in fact wrongdoing on the part of anyone. And it is only an investigation, a proper and thorough investigation, will determine whether these matters which were in our hands, which we passed to the Integrity Commission, were actually just simply errors, or whether they point to serious criminal conduct. The next thing we know, the Attorney General is now making a song and a dance about not being told that he was being investigated. And on that basis, he expects that the investigation will not take place. Well, today, I am calling on the authorities to ensure that the investigation of this very serious matter takes place so that the population can be satisfied that high-ranking officers have not corrupted the process at customs, at VAT, and at the licensing office in an attempt to give a benefit to person or persons who were not entitled to that benefit. And with respect to the authority of the Integrity Commission to do this investigation, it is our view that that authority is in no way impaired. And I'll tell you why. The Integrity in Public Life Act, let me read it for you. Because you see, the Attorney General has a habit of giving legal advice to this country, which has no basis in law. He is now today claiming that he was wronged by not knowing that this matter was being investigated, and on that basis, he's calling for the chairman of the Integrity Commission to resign, and I presume the next comment would be that this matter will die a natural death, and we'll know nothing about it. Let me draw your attention to the Integrity in Public Life Act. And I'm not here making any case for the Integrity Commission. The Integrity Commission can handle its own stories, good, bad, or indifferent. I'm speaking here as the opposition leader, speaking to prevent the public from being confused by the Attorney General, so that they will understand what the issues are before the country, so that the public will know what to demand and what to expect. You may recall it's the same Attorney General who, when the emails went to the Parliament, the Attorney General and the Prime Minister spent days telling this country, giving us free legal advice, that the Integrity Commission had no authority to investigate that matter. Again, self-serving legal advice that was plainly wrong. He's now talking about the chairman should resign because he wasn't informed that he was being investigated. The law, Integrity in Public Life Act 2000, section 33, the Commission. Let me read for you what the law is. The Commission, A, may on its own initiative, or B, shall upon the complaint of any member of the public, consider and inquire into any alleged breaches of the Act or any allegations of corrupt or dishonest conduct. That's section 33. That is the power given to the Commission to consider and investigate. Section 34. In carrying out its function under section 33, which I just read, the Commission may A, authorize any investigating officer to conduct an inquiry into any alleged or suspected offense. B, require any person in writing to produce within a specified time all books, records, accounts, reports, data stored electronically or otherwise, or any other document relating to the functions of any public or private body. Those are the clauses that give the authority to the Commission to respond to any complaint or to initiate any investigation of its own volition. Nowhere in there does it say that you have to tell anybody that you are going to investigate them or that you are investigating them. However, under the principle of natural justice, when we passed this law, and I happen to have been a member of the Parliament when the law was passed, to ensure that natural justice prevailed, the Parliament did not leave it up to the Commission to ensure that natural justice prevailed in treating with citizens. In section 38, it put a stricture on the Commission, and this is the only stricture on the Commission. Section 38. And let me read it for you. It says, no report concluding that a person to whom this act applies has failed without reasonable justification to fulfill a duty or obligation under this act shall be made, in other words, no report shall be made until reasonable notice has been given to such person of the alleged failure and the person has been allowed full opportunity to be heard in person or by counsel. So in other words, it says that the commission can investigate, it can consider, it can do whatever it wants while it's interested in a person in public life. The one thing the commission cannot do, as prevented by law and spelled out here, is to come to any conclusion about the matter, about the person, and prepare any report of that nature without allowing the person the opportunity to respond to any allegation or to respond to anything that the commission may be considering. That's the law. I've seen it in the newspapers, in fact in one editorial, I think it was The Guardian, using my own case as an example to point out that the Attorney General's fulminations now has some basis. Let me tell you what the difference is. And the public is not to be misled by misinformation. In my case, the Integrity Commission received a complaint about me. No, man, nothing wrong with that. I had no complaint with that. The Integrity Commission then appointed an investigator to investigate me. Nothing wrong with that. I never complained about that. The investigator eventually came to me. No complaint. Identifying himself as an investigator hired by the Integrity Commission, authorized under this act to investigate. No complaint about that. The investigator spoke to me and went off to do his investigation. I never complained. As a matter of fact, I asked the commission later on, what is it you're interested in? Granted, they never responded. That's another story. However, later on, it came to my attention that the commission didn't only conclude a matter, they prepared a report about me and they sent the report to the DPP. At that stage, I had a complaint. The commission had broken the law because they violated Section 38. I was not complaining that the commission didn't tell me they were investigating me. That was not the substance of the complaint. The substance, but they broke the law. They concluded, made findings, and they sent it to the DPP. Only then was I made aware of what they were investigating, and they never gave me the opportunity to respond to the allegations. Can you see a difference? I went to court, and I asked the court to let me see what is being said about me by the Integrity Commission in this report. The court did not comply. The court didn't agree. But the court held the commission guilty for breaching Section 38. And the commission was found guilty of malfeasance in public office. But the court did something else. The court said they will do nothing that will prevent the Integrity Commission from conducting the investigation. So the court did not in any way put any stricture to prevent the allegation from being investigated. In fact, the court ordered the Integrity Commission to follow the law, put the allegations to me, allow me to respond to them. And that is what the law expected, and that's what the Integrity Commission did under the court's order. And when the allegations were put to me, I was able to respond to them, and I was able to respond to them in such a way that on completing its investigation, the Integrity Commission now came to the conclusion that I had no case to answer, the allegations were false. So I do not want the Attorney General and his friends and supporters, whoever they are, to misrepresent what happened in the court in my matter, with him complaining that nobody told him he was under investigation, and on that basis the chairman should resign. The Integrity Commission resigned in my matter because they were found guilty of breaching Section 38. They gave me no opportunity to be heard. They concluded their investigation, however they did it, and they sent the report to the DPP in breach of Section 38, a clear breach of the law. And then when I went to the court ordered them to follow the law, which is give me the opportunity to respond, and I was able to respond. I hope the Attorney General would be able to respond in similar manner and show that there is no problem with all these allegations being made and the issues about these documents and these vehicles. But to get up and tell the country that because you did not know that it was taking place, something has happened terribly, which the investigation now must peter out and the chairman must resign, is to mislead the population. Right? Because there are differences between courtesies and law. Right? I mean, it is up to the commission to determine at what stage they come to you. It's like the police. The police could be trailing you for months and be interested in you. And then they will decide when they come to you. They might have got some information, they might got more, but the commission will decide when they come to you. But if they go further and do a report or make conclusions about you without coming to you, that's another story. Because you see, one of the things the commission can do and has done is to dismiss allegations. An allegation goes to the commission about Mr. X or Miss Y. The commission can look at it, and by looking at it, by considering it, can determine it's frivolous and dismiss it right then and there. How does the commission do that if it doesn't do some element of investigation to determine it's frivolous? To be able to determine that this is frivolous, you have to look at it in some way. And the minute you start looking at it, you can be deemed to be investigating it. And that's why the law specifically spells out in Section 38 that all this looking at and considering, you could do as much as you like of that. But before you go any further in concluding a person's guilt and preparing that guilt in any report, satisfying yourself that the officer has done something wrong, you have to let the officer know that the person is under investigation, and you've got to put the allegation to the officer so the officer can respond. And that is where the Attorney General is right now. We expect that the Integrity Commission will put these matters to him, and he will respond, and we as a country will know whether those holding office, right, deserve to be there. I am not going to say anything this morning about the Attorney General and whether he should be there or not, because this Attorney General seems to think that anything goes in the office of Attorney General. And we have other departments of state now, customs, VAT, licensing, involved in his personal business, because the purchase of that vehicle, the payment or non-payment of duties, the sale or transfer of that, all of those are private personal matters. I hear him saying that these matters are in the ministry. These are not ministry matters. When the vehicle is bought, it's your personal vehicle. All that happens is a transaction of a loan. If you sell it, it's your personal transaction. To transfer it, it's your personal liability. So I am not going to be allowing this country to be misled by the Attorney General that all these matters are in the ministries and they can go there and get it if they want. As Attorney General, he is required to answer whether improper actions were being taken with respect to the attempt at licensing that second vehicle. That is what we send to the Integrity Commission. How did these documents get so confused? How did they get signed by public officers? We have submitted documents to the Integrity Commission, signed either fraudulently or properly. Either way, there are issues, because if they are signed properly by the officers detailed to do so, then we want to know why they were signed in that way when certain developments were taking place. And if they were not signed by those officers, then we are talking about fraudulent conduct. And the answers must be had. And the Attorney General trying to muddy the water about the Integrity Commission's chairman is not going to be allowed to distract us from the issue that we put in front of the Integrity Commission. And he can spend as much time as he wants trying to muddy the issue and confusing the issue. This office that sent the complaint to the Integrity Commission, we will focus on the complaint that we have sent. And it would be good if the press understands what the issue is. And if other issues come up, fine. But the kernel of this issue is whether attempts were made at the customs, at the VAT office, at the licensing office, to license a vehicle duty-free when the previous vehicle had not been properly discharged of that facility. That is the issue.